Wiretapping?
Wiretap.
They have
a legal wiretap.
You mean to say that a magistrate is going to authorize a wiretap to find out if a couple is using contraceptives?
They couldn't they, the law?
Unbelievable. Unbelievable.
More from then-Senator Joe Biden in a moment. That was 1987 during a discussion on Griswold, among the many one-name Supreme Court cases that define the trajectory of America's battle over abortion rights. In 1973, Roe v. Wade sat as the most famous, when abortion was ruled a constitutional right.
It declared the entire nation must follow one standard, a standard not determined by the American people, but by unelected judges. And the standard was among the most liberal in the world.
Today, it's Dobbs after the Supreme Court overturned Roe.
This decision also risked the broader rights of privacy for everyone. That's because the fundamental right to privacy, which Roe recognized, has served as a basis for so many other rights that are ingrained in our fabric of our country.
I do think that many expect that this Roberts Court will overturn affirmative action in schools, which will lead the way to overturning affirmative action in corporate America and in other institutions.
We won't go back!
I think it's possible to argue that the nation's drift into irreconcilable polarization began not with Donald Trump's election in 2016, but on June 7th, 1965, when the Supreme Court established a right of privacy in Griswold v. Connecticut. Aside from its role as a precursor to the Roe decision, Griswold is remembered for Justice William O. Douglas's assertion that a right of privacy was discoverable inside the Constitution's penumbras formed by emanations. And it's that poetic dictum that takes us back to 1987 and Robert Bork's Supreme Court nomination hearing.
Griswold involved a Connecticut statute which banned the use of contraceptives. And Justice Douglas ended that opinion with a rather eloquent statement of how awful it would be to have the police pounding into the marital bedroom. And it would be awful, and it would never happen, because there is a Fourth Amendment.
The Fourth Amendment, of course, prohibits unreasonable government searches, but for the man that would be president, the pursuit of rights penumbras did not end there.
Let's assume they were drug dealers. They were also accused of, there was evidence that they're involved in some other illegal activity, and there was a wiretap.
And they hear discussion of contraceptives?
Yeah.
Nobody is going to get a warrant for that, and no prosecution is going to be upheld for that.
But the reality is that Justice Harry Blackmun, in his 1973 Roe decision, cited the Bill of Rights or its penumbras to justify the creation of a national abortion right.
Nobody knows what that thing means. You have to define it. You have to define it. The court has not given a definition.
And once the Supreme Court had established that the already expansive Bill of Rights had penumbras, we were off to the rights races.
The only reason it stayed on the statute book was that it wasn't enforced. If anybody had tried to enforce that against a married couple, he would have been out of office instantly and the law would have been repealed.
What matters here is that Bork and others were arguing that finding such deeply personal rights in the Constitution was perilous. They were right.
Our vision should be of an America where abortion is safe and legal, but rare.
Abortion quickly divided into two phrases, pro-life and pro-choice, with no middle ground. Then last year's Dobbs decision transferred this all-or-nothing dispute to the states.
Different people in different places are taking different paths. That's what the founders of our country envisioned. It's the reality of living in a democracy.
The current battle over the High Court is the political left's attempt to restore the Roe standard of a nationalized, one-size-fits-all legal right for issues of their choosing.
We could be undoing a half-century of diversity, equity, and inclusion initiatives around the country.
What happened with abortion in the states after the Dobbs decision strongly suggests that Americans do not want to forfeit their opinions forever to a national authority on issues that are so deeply personal.